All right, hello everybody. Hi, we're back again talking about the state's original written motion in the appeal of the overturned conviction of Brendan Dassey. Looking into the case law still. So this is going to be the last case of a confession that the Seventh Circuit Court ruled was voluntary. This is going to be the final example of that, and then I'm going to move into the next couple videos are going to be about confessions that the Seventh Circuit Court ruled were involuntary. So, but this will be the final one of which they ruled that it was voluntary. So, anyways, this is the case of Riley versus Franzen. This case is kind of interesting to me. It's this kid was him and his brother were picked up. There was apparently a crime committed at this cemetery. 2 people were killed. Anyway, this kid and his brother were picked up apparently some distance away by some police officers. They were asked, where are your weapons? Where are your guns or whatever? And the 2 brothers were like, we don't have any guns. We don't know what you're talking about. They were then arrested and taken back to the cemetery, left in the cop car. Now, the cop car didn't just park on the perimeter where all the other cop cars were. The car pulled all the way up into the cemetery to where it was pretty close within eyeshot of where the body lay with a blanket over it. And it was parked right where Mr. Riley could clearly see the blanket over the body, and they were left sitting in this car for quite some time. And the reason why I say that they were kind of far away is because it's reported that he felt that from where they arrested him, where they were actually picked up, to get back to the cemetery, felt what he thinks was about 5 or 10 minutes. Which means they must have been kind of distant, far away from the cemetery by that point. But, I don't know. Anyways, we'll go into more of the fishy stuff about this. So, they were left in this car for apparently quite some time, where obviously he could see the body under the blanket. And there was even the point where they brought 2 of the eyewitnesses that had seen this happen, brought them up to the vehicle. And those eyewitnesses failed to identify Mr. Riley and the Riley brothers as the suspects. Failed to ID them. So right there, we already have. They were kind of far away from the cemetery. Don't know if they were really close enough to be the ones that perpetrated this crime. But then also, the eyewitnesses didn't recognize him and ID him. Now, okay, maybe they have other reasons, I don't know, to suspect these 2 kids, but they also don't have any weapons on the kids. And, and they obviously haven't found any weapons, otherwise they wouldn't have asked, right? So there's all this that makes it seem a little fishy to start. But anyway, so there's also the fact that the parents were actually there at the cemetery at that point. At some point they arrived there, and they were still not allowed to see Mr. Riley, the Riley brothers. They were not allowed taken over to the cop car to talk to their children. Now, to my mind, this seems to be a pretty consistent earmark when police are dealing with juveniles and they're trying to get a confession and trying to make a charge stick, essentially, and what they'll do with a juvenile by denying them the right to see their parents and stuff like that. I think it's horrific. Personally, and I think now I understand why the amici curiae motion ended up getting filed and why they keep talking about juveniles and their Fifth Amendment rights. Looking at this case, it's kind of worrisome, and so I think I understand now a bit more of why that motion got filed. This case is kind of unfortunate. The circumstances of it, to me, seem a little bit, not quite right. And we'll get into it here in a minute. I'm going to show you some screenshots of where it talks about them denying him his request to see his father when he asks. So, which I think is huge, which I think is super, super huge. But anyways, we'll get on to that here in a minute. But right now I'm going to go ahead and show you the initial report where they talk about picking him and his brother up and then taking them over to the cemetery. And what happens there, and the fact that the parents did actually show up at the cemetery, but were not able to see their sons. So I'll show you that right now, coming up, and here we go. Essentially, two things pertinent to our inquiry occurred during the brother's stay at the cemetery. First, the body of one of the homicide victims, covered by a blanket, was lying in Riley's view. He knew that it was there, but no coercive reference was made to it by any police officer. The two young boys who had originally told the police where the suspects fled were brought to the police car, but were unable to identify the petitioner or his brother. The petitioner's father and stepmother had been brought to the cemetery, but were not allowed any contact with the petitioner. There is no indication that Riley was interrogated at the cemetery or made any challenged statements while there. So yeah, I'm just not seeing where this seems just of them, not allowing, not bringing the parents over to the police car where they had their sons. I mean, that just seems odd to me. I mean, I don't understand the whole, keeping the children away from the parents, because when you're 16 years old, your parents are responsible for you. They're responsible for the things that you do. If you're out in public and you damage something, your parents are responsible to pay for that. They're responsible for you because you're not responsible for yourself yet. Right? Right. So that one particular point really doesn't sit well with me. And you're going to see later on here in the video, I'm going to show you, in the opinion of one of the dissenting judges in this, that it was a sticking point for him too. He didn't like it either. It didn't sit well with him either. So we'll get to showing you that in a minute. But my other issue with this here is that if you're picking these two boys up and you're looking to take them down and talk to them and potentially get a confession out of them, or maybe just see if they know anything because they were nearby, why would you take them to the crime scene first where they could actually see what was there? Because you wanted them to be able to give a more reliable confession? Because that's what it seems like. That's the only reason I can see any sense of why somebody would do that with their suspect, is because they were trying to be sly or slick and put ideas into the suspect's head so that if they begin talking, they'll be able to describe the scene, because they saw it. I don't like that at all. I don't think that was very good at all, that they took these two suspects to the crime scene itself like that, so close to what had happened, where they could see, like I said, one of the bodies under a blanket and stuff like that. To me, that's unacceptable. That's totally unacceptable. They should never have done that. But, so that's another thing that sticks out with me with this particular case that I don't like. And like I said, this case is really making it hammer home to me why I think that the Mishi Kurai motion got filed. Because, yeah, looking out for the Fifth Amendment rights of minors at this point seems like some things need to be changed. Some things need to be looked at a little differently than they currently are. But I will add that this particular case is still, just like the other ones, I do not feel that it is a fair comparison to Brendan, because number one, this kid he doesn't have the educational or the developmental differences. He doesn't have that suggestibility and that learning disability that Brendan has. It's like I said, they're both the same age, but they're not the same intelligence and background. And that's what I've been saying about all these cases that so far that Brad Schimmel has cited in his motion. They're not the same as Brendan. These cases are different than Brendan's. But having put that aside, this case still bothers me. This particular case right here, I still have issues with. And I feel fine having those issues with it, because one of the judges wrote a dissenting opinion about this and basically touches on exactly what bothered me about it. So I'll get to that, as I said. So anyways, I'm going to go ahead and show you right now some of the two little documents, or two parts of the document here that talk about them denying Mr. Riley the ability to see his father when he asked. And the thing about it is that Mr. Riley is saying he wanted to see his father because he wanted to ask his father to get a lawyer or somebody there to help, him. He wanted to invoke his Fifth Amendment right to a lawyer and to be silent. But they didn't want to let him talk to his father. And what the courts are basically saying is that they didn't equate him asking to speak to his father to him trying to invoke his Fifth Amendment right. Well, I don't care. I don't give a damn. He was 16 years old. He was being interrogated by police, and he asked for his father, and his father was there. It should have happened. No excuse, in my opinion. None. So, that's the way I feel about that. So I'm going to go ahead and show you those documents right here coming up, and then we'll come back one more time, and then we'll talk about the dissenting judge and what he had to say about this. So, despite the denials of Sergeant Reed and Officer Jackson, the district court believed Riley's testimony that after he initially denied having been at the cemetery, Riley requested to see his father. At the evidentiary hearing, Riley made an offer of proof, indicating that he wanted to ask his father to obtain an attorney for him. This is consistent with Riley's state court testimony. However, during the interrogation, Riley did not indicate why he wanted to see his father. After this request was refused, Riley confessed to the homicides. While doing so, Riley was nervous, his voice cracked, and a tear appeared in one eye. After confessing, Riley repeated what he had said in abbreviated form to his brother Ernest. He also signed a statement which was transcribed by a court reporter. The taking of that statement was completed at approximately 11 p.m. Following the interrogation session, Riley was fed a chicken dinner. After midnight, the petitioner and his brother were permitted to see their father. Far too late at that point, in my opinion. The fact that his voice was cracking and a tear appeared, he wasn't allowed to see his father. There's just some issues here with this for me. Big issues for me. Okay. Thus, we cannot accept uncritically Riley's characterization of his request for his father. First, we conclude that Riley's request was not an invocation of his right to silence in Fair v. Michael, which is unfair because Fair v. Michael is in regard to a probation officer, not a father. But anyways, the court reversed the judgment of the California Supreme Court, which held that a juvenile's request for his probation officer constituted an invocation of the defendant's Fifth Amendment privilege. The court analyzed the request primarily to determine whether it could be construed as an invocation of a right to counsel. However, it also rejected the argument that the request indicated a desire to remain silent. Now, I'm sure that kid probably felt like he had a close relationship with his probation officer, probably why he requested him. But they're right. It's a conflict between the probation officer, because he works for the state, essentially. So there's, much different thing asking for the probation officer than a father. I mean, to me, that's night and day. It's completely different things. I don't know how they could apply that law. And you'll see coming up that the Supreme Court Justice who had his dissenting opinion about this felt the same exact way, that the Fair versus Michael was improperly applied. So that's where we're at. All right. So you see there in the documents them like basically justifying the denial of the request to see his father because of this decision of Fair versus Michael, which is not a fair, is not a fair comparison, because in Fair versus Michael, the defendant had requested to see his probation officer, okay, not his father. Okay, probation officer is different because a probation officer has a duty to the state, because he's a probation officer, to report any wrongdoing by the suspect. So they didn't see that as him trying to invoke a Fifth Amendment right or trying to exercise his right to remain silent. They saw that they didn't see the probation officer as a person that was really in a position to help him in that way, without it being a conflict of interest, essentially. Well, that's not going to be the same case with somebody's father, right? The huge difference between a probation officer and somebody's father. So that's where I disagree with this, hugely, big time. And then, and I'm glad because the judge in the document that I'm going to show you right now, the dissenting judge, feels the same exact way. He basically says that it was an improper applying of the Fair versus Michael, because it doesn't fit this case, because a probation officer is not the same thing as a father. So essentially says that. So I'm going to go ahead and show you guys that here. in this next document, and that'll be the end of it. I'm going to go ahead and end it on the document. So if you guys haven't already, please hit subscribe. Coming up, just so you know, coming up in the future here, I'm going to be moving into the cases, as I said in the beginning of the video. I'm going to be moving into the cases that this court had basically deemed the confessions involuntary. So we'll be moving into those cases next, just so you know. But here we go with the dissenting opinion of one of the judges in this case, and his reasoning for dissenting coming up here. So here we go. Okay, so this is the dissenting opinion of Supreme Court Justice Marshall, who offered this opinion in the Riley versus Franzen case because he had concerns. Obviously thought this would be used later on and would be an important piece of law. So on direct appeal, the Illinois Appellate Court rejected the petitioner's challenge to the admissibility of his confession, People versus Riley. The Illinois Supreme Court denied leave to appeal. The court denied a petition for a writ of certiorari. And I dissented, noting that there was a conflict of authority on the question whether an accused child's request to see a parent must be honored by the police before continuing interrogation. Having exhausted his available state remedies, Riley filed a petition for a writ of habeas corpus in the United States District Court for the Northern District of Illinois. The court ultimately rejected his claims that the confession should have been suppressed. The United States Supreme Court of Appeals for the Seventh Circuit affirmed the Court of Appeals relied heavily on this court's recent decision in Fair versus Michael, which held that the juvenile's request for a probation officer did not necessarily constitute an invocation of his Fifth Amendment privilege. Petitioner again filed a petition for a writ of certiorari in this court. The petition is now denied. Because I continue to believe that the issue presented here is substantial, and because the decision of the court below further contributes to the conflict among authorities, I dissent. The court's decision in Fair v. Michael does not determine the result in this case. Fair v. Michael emphasized that a probation officer has a statutory duty to report wrongdoing by the juvenile and serve the ends of the juvenile court system. Thus, he would be particularly hampered in his efforts to protect the juvenile's legal rights. Obviously, a parent is in a very different position. So this guy's just pointing out the obvious there, that they are essentially kind of improperly applying the Fair versus Michael case in this as, you know, as a precedent for why they denied Mr. Riley's claims here. So I think he's right. I believe he has a point, because there's a far cry between a probation officer and a father. Two different things there. Way far cry from each other. So anyway, that's about it for this video. Please, if you haven't already, please hit subscribe. And obviously all the information that I've shown you here, I will leave links to it down below, and so that you can check out the full documents for yourself if you like. And have a nice day.